valid license to freely assemble and or protest, okay? Now, the gist of this, I want you to see the significance of this case in view of the case we gave you before that. Murdoch versus Pennsylvania clearly established that no state can convert a secured misdemeanor privilege and issue a license and fee for it. Everybody got that. Shuttlesworth versus Birmingham, Alabama said that if the state does convert your right into a privilege and issue a license and a fee for it, you can ignore the license and fee and engage in the right of impunity. That means they can't punish you, they gotta let you go. Alright? Does everybody see that? It's very important that you understand first your Constitution is the supreme law of the land in which you have that right. And that right shall not be infringed. It's supposed to be enforced in favor of you, the clearly intended and expressly designated beneficiary. It's very important that you understand that no state may convert that right into a privilege and issue a license and a fee for it. If they do, Shuttlesworth versus Birmingham, Alabama says you can ignore the license and engage in the right with impunity. That means they can't punish you. Now, the next case is very important. It's very important that you see the argument. Okay? That's United States versus Bishop. That's 412, volume 412, United States Reports, page 346. Now here, United States versus Bishop is a very unique case. Basically what Bishop does is it sets a standard for what constitutes a criminal violation in terms of willful intent. Okay? Willfulness is one of the major elements that is required to be proven. In any criminal element, you have to prove, one, that you're the party, two, that you had a method or an opportunity to do the thing, and third, that you did so with a willful intent. Now, when we get to willful intent, willful is defined as an evil motive or intent to avoid a known duty or task under the law with moral certainty.
See?
Obviously, in the previous two cases, you have decided that you have relied on the United States Constitution, and you have relied on the decisions of the United States Supreme Court. So, could you have willfully done any deed or crime? Obviously not. So, guess what? This case stipulates that you have a perfect defense to the element of willfulness. Alright? Since the burden on the prosecution is to prove that you did willfully knowingly avoid a known duty or task under the law with moral certainty, he cannot perform that task, can he? Because it's obviously you have a constitutional immunity today. The previous case, Shuttlesworth versus Birmingham, Alabama, said they couldn't even punish you. The case before that said you didn't need a license for the exercise of the right. And the case before that said your constitutional right is supreme over any state law. So if they pass a law in violation of your Constitution, the Constitution overwhelms the state law. So the law doesn't even exist in law. Does everybody see that? Now, since the prosecutor doesn't have a cause of action for which relief can be granted, Your Honor, may it please the court, counsel is specifically precluded from performing his major task. Therefore, Your Honor, may it please the court, at this time I would motion most graciously for a dismissal with prejudice for failure to state a cause of action for which relief may be granted by this honorable court. And I'd kind of like to put my cost of fees for you to defend this badly frivolous and spurious complaint, sir. May it please the court. Laughter will usually break out thereafter. At which point the judge will usually turn to the prosecutor and say, well, Mr. Rose, what do you got to do about this young fella? And he'll say, I go for the motion to dismiss, Your Honor. The judge will turn to him and say, that's a good answer, because I don't think you're ready for this kid today. And 40 attorneys will break out laughing. Okay, that's actually happening, people. I'm telling you, this argument is a killer argument. It's good for every single constitutional right you've got. All you have to do is fill in the blanks. What constitutional right? Prove that you have a constitutional right. Tell them the state doesn't have a right to convert that right into a privilege. Tell them that they can't even punish you if they do. And then claim that the prosecutor can't prove willfulness, so you obviously didn't do no crime, and then flip around and demand for your dismissal, which is your right, and get your costs and fees grabbed and defend this frivolous case, may it please the court. And I promise you, you will be amazed. 40 attorneys will jump up and say, yeah. They'll come up and shake your hand and tell you that's one of the most magnificent arguments they've ever heard. They'll tell you you got something like King Kong, taken on the Bar Association or whatever. I'm telling you these things will personally happen to me. I can relate to exact cases. It goes for practicing law without a license. Obviously, you got a right to work. You got a right to contract your right to work as you see fit. How does some arbitrary increases Bar Association see fit? Right? Does that make sense to you? You don't want to belong to the union, that's your right. This is a right to work state, right? Bottom line is this. They cannot compel you to have a license or pay a fee for the exercise of your right. And if they do, you can ignore the license and be engaged in the right with impunity. That means they can't punish you. Since you got a perfect defense to the element of willfulness, they cannot put violation. They have to dismiss. They do not have a cause of action. Now, this argument I'm telling you has taken us over 18 years to develop in courts and in law libraries over the years, just kind of compiling and arguing cases and doing this. This argument is a killer argument. They have yet to ever won against us on this argument, nor could they in the United States of America as long as the Constitution stands. I'm asking that you pay attention to this argument and start utilizing it. We'll show you some of the techniques later in the second half, right? Now, the word willfully has the same meaning, right? Controlling the voluntary, intentional violation of a known legal duty. And the distinction between the statute is found in the additional misconduct that is essential to the violation of the felony provision. If they can't prove willfulness, they can't prove nada. Okay? Everybody got it? Now, let's go to the next one. Now that you've won and your rights have been violated, the next thing they will claim, well, we acted in good faith, or what we acted in good faith, we had good faith reliance that you broke the law. Okay? And that means you can't sue us. That's a lie.
Bullshit, yeah, exactly.
See, since these two cases, Owen versus City of Independence, which is recorded at 100 volume, you want to look at Supreme Court reports. Now, that's a different report. Supreme Court reports will actually say on the back of the reporter, Supreme Court reports. It won't say U.S., it'll say Supreme Court reports. So that's a different volume. It's a newer report. So you want the 100 volume, and you want to look up Supreme Court reports, and you want to turn to page 1398. There is also a counterpart case to this own case, which is Maine versus Thibodeau. This site for those. Okay, I gave you Owen versus City of Independence, so I'll give you Maine versus Thibodeau. Maine versus Thibodeau is recorded at 100 Supreme Court. That's 100 volume. Supreme Court reports, page 2502. Now, basically, the summation of what these basic arguments say, where plain language of a statute supported by consistent judicial interpretation is strong, it is not necessary to look beyond the words of the statute, right? Now, these are both civil rights cases. The right of action created by statute relating to deprivation under color of law, of state law, of a right secured by the Constitution and the laws of the United States encompasses claims which are based solely on statutory violations of federal law and apply to the claim that claimants had been deprived of their rights in some capacity to which they were entitled. Now, whenever this happens, you must understand something. And that goes for both Maine versus Thibodeau and Owen versus City of Independence. And I'll tell you the brief synopsis on both these cases. Owen was a police chief in the town of Independence, Missouri. And he got a right with the city council, and they indiscriminately fired him without just cause. Owen turned around and sued. They claimed that they acted in good faith. The Supreme Court said, sir, you are deemed to be officers of the law. You are to advise us of the law. You can hardly claim that you acted in good faith for a willful deprivation of the law, and you certainly can't claim ignorance of the law because a citizen out here in the street can't claim ignorance of the law, and it makes the law look stupid if an officer of the court or some officer of government doesn't know the law, and then they go ahead and abuse somebody's constitutional right. So in matters of constitutional rights, both these cases uphold one point. The point they uphold is that whenever they violate your constitutional rights, they do so at their own peril. And it even says that in Title 18 United States Code Section 241 and 242. It says that upon conviction, you are subject to a $10,000 fine, 10 years in jail, or both, and if death results, life in prison. They're telling you, don't violate somebody's rights. Please, don't do that. Title 42 United States Code Sections 1983, 1985, and 1986 clearly establish your right to sue anybody that does that. Now, they're going to claim you can't sue them because they have judicial immunity. Well, guess what? These two cases remove judicial immunity. There is no judicial immunity for violating somebody's constitutional right. Judge, you are deemed to know the law and sworn to uphold it. You can hardly claim that you act in good faith or willful deprivation of the law, and you certainly can't claim ignorance of the law, for that would make the law look stupid. For a non-knowledgeable judge to claim ignorance of the law when a citizen on the street can't claim ignorance of the law. Therefore, there is no judicial immunity. I'm going to get that across. I don't know how many attorneys come up to me all the time and tell me, well, they're immune because they acted in good faith.
Bullshit.
They're just not reading their court. They're not reading their court reports, because if they had read their court reports, they would have known this case has been on the books since 1982. Both these cases came done.
36 years.
So I want you to pay attention to these cases. Somebody tells you they can violate your rights
Almost
with
exactly.
impunity, you just kind of
I
smile.
was born in February, and that's when it was posted.
Okay. Okay. Now, the next case we want to talk about is Briars versus United States. We mentioned it previously earlier. Briars is recorded at 273, volume 273, U.S. Reports, page 28. Okay? Now, Briars versus United States is a unique case.